Good afternoon, everyone. I'm Tanya Walker, and this is a webinar on answering your questions and providing recommendations for your COVID-19 related property law issues. This is a re-recording of the webinar. We have had so many questions that we've incorporated some of the answers now into our presentation, but we will also provide a link to the questions that were asked and our answers, because there are over 30 questions presented to us during this webinar. Now, I know that you are all busy as professionals, business owners, and I would like to say first and foremost, thank you for taking the time to join us. I really appreciate having your time. Secondly, I'd like to thank our friends. We have had over 100 people register for this webinar, and part of the reason why is because our friends have encourage other people who might be interested in property law to participate in this webinar. We will send a link to the contact information of all these names, institutions, companies, people that promoted our webinar after the conclusion of this webinar. So here's a summary of what we will speak about today. The first is I'm going to tell you briefly about information that will be sent in an email to you after this webinar, housekeeping, how you would participate in this webinar and future webinars, and an introduction to our legal team. Secondly, I am going to provide an update on the government's response to COVID-19 from a property or unique law perspective. I really am going to focus on the laws that have been created since Friday. And then we'll go into the property law questions. So the last webinar that we had, we were told that we should try to encourage engagement. So this time around, we're going to have a poll. You're going to provide an answer, and then we're going to show you the answers and provide you suggestions and precedents on how you can deal with this problem in the future. It will range from contractors to commercial tenants to condominium sales. Lastly, we'll wrap this up. Now, this webinar, our disclaimer, is for general information purposes only and is not intended to be independent legal advice. So in our webinar and future webinars, the way that you would participate is by raising your hand. You'll see the button below, and there will be 6 polls in this webinar and future polls. And so if you want to vote, a box will pop up and you click on it, click submit, and then it will submit what your answer is to me. And at the end, I'll show what the majority was in terms of the response. Afterwards or during the webinar, you can chat by typing your question in the chat button. I encourage people in our webinar held this afternoon to just write their questions right away. We are trial lawyers. We're used to answering on the fly. However, we were going back and forth quite a bit, and now we're going to categorize the questions and answers a little bit better. On May the 8th, Jordan Koenig and Rafina Rashad will present together a webinar on employment law. So I encourage you that if you enjoy this webinar, that you participate in our webinar in the future, where you can learn more about employment law. Our last webinar was on April 6th, and we discussed employment law, property law, and contract law. This webinar will not rehash any of that information provided on property law. So I encourage you that if you want to learn more about property law issues and how to deal with them, that you click on that link and watch that webinar. Your feedback is also very important to us. And if possible, we ask for you to complete the survey. And this link will also be included in an email that will be sent to you after this webinar. And it's Walker Law maple syrup branded maple syrup. And so you can use it for your pancakes. We recognize that you are probably cooking a little bit more and might have more use for this. And the pancakes are really for illustration purposes only. You will not get any pancakes mailed to you in your package. So just a brief introduction to your host. My name is Tanya Walker, and I opened Walker Law 10 years ago. I've been practicing for 14 years, and I also appear as a legal analyst on several television stations, which includes CTV, CBC News, and CP24. Jordan Routliff is an associate lawyer with our firm. He specializes in property law. We're very fortunate that he articled with us, and he joined us as an associate last year. The remainder of our legal team is Jordan Koenig, who I introduced earlier. He will be hosting the webinar on employment law. Marley Annette, who is our paralegal student, and Rishi Nagashar, who is our articling student. And I thank you, Rishi, for your hard work in helping to put this presentation together and answering the questions during the webinar that was held earlier. So I'm going to start off and focus a little bit of time on the new law created by the government of Canada and Ontario on Friday. And so on Friday, there was the Canadian Emergency Commercial Rent Assistance Program that was announced. And this is administered by your mortgage company. So the building should have a mortgage. That's the first thing. And it's the landlord that applies for that mortgage. Or for that rent assistance. The tenant cannot apply. And there was a question asked where if there is a third party, such as someone helping that landlord, or should that person deal with this, or should the landlord? And the answer is the landlord should. It applies to tenants who have experienced a 70% decrease in revenue and pays a maximum of $50,000 per month in rent. The federal government will offer a forgivable loan to commercial landlords for 50% of that original rent. It's if the landlord agrees to reduce rent by 75% between April and June. This can be applied retroactively because many rent usually is due on the first of the month. So it can apply as of April 1st, and it's expected this to be operational by mid-May. There was also another question asked about if documentation concerning this between a landlord and tenant can be agreed to in advance. My answer is yes, because then it gives you time to go back and forth and consider all options. Now, just to illustrate this, because it took me some time to wrap my head around it, let's pretend the rent of a commercial tenant is $100 a month. You'll see in the red box that the tenant is red. Number one is that the landlord will have to reduce the rent by 75%. So instead of owing $100 per month, the landlord will expect to receive $25 because that's a 75% rent reduction. Second, if the landlord agrees to do this, the two governments working together will pay 50% of the original rent to the landlord. So the tenant has to pay $25. The governments will pay $50, and now that the landlord has received $75 out of the $100. The old rent due would have been $25, and the landlord must agree to forgive this. And in return, the landlord cannot evict the tenant. So we were also asked the question of, suppose the landlord wants the tenant to pay 100% and will send to the tenant some of the money received, and in return won't lock out the tenant. That's a problem that goes against the spirit of this agreement. So if a landlord decides to do that, there is a chance a landlord might end up in emergency court, because the courts are dealing with emergency matters, and we have dealt with ourselves and have seen leasing matters or commercial tenant matters as emergency matters. So going into the province of Ontario, Ontario has, there's quite a few laws for Ontario, but I'll get into the most recent ones and the ones that apply to the court system. First of all, on March 14th, Ontario froze limitation periods. So typically speaking, you have 2 years to sue. That's typical. And so say your 2 years was up to sue on March the 15th, this freezing of the limitation period actually put a pause on it, right? And the pause will be lifted as soon as the limitation period is unfrozen. So that's what it means. That's what happened with the construction law, the Construction Act. On April 16th, the government removed the limitation periods involving this, maybe because there are difficulties getting payments or enforcing certain lien periods. On April 24th, which was Friday, 2020, there was two main changes. Number one is that penalties and interest for businesses that miss remittance deadlines for various provincially administered taxes was eliminated. So there are no penalties or interest that will be charged until after September the 1st. Also, MPAC every 4 years, whether you own residential property or commercial property, every 4 years, MPAC attends the property and decides on what the value is, and you're taxed based on that. This is a year where that's supposed to be completed, and that has been postponed until next year, perhaps because people don't necessarily want anyone visiting their home at this time to assess it for the value of it. The day after, on April 25th, there was an introduction of pandemic pay, and that is effective from the day before, April 24th, to August the 13th. This is a temporary increase of $4 per hour that's administered by the government, not the employer, with a bonus of $250 per month for those that work over 100 hours per month. So there are two categories of pandemic pay. There's certain occupations and there's certain workplaces. And so one occupation are nurses. It doesn't matter where you are as a nurse, where you're working, you will receive a temporary increase of $4 per hour. And then there are workplaces such as hotels that have been converted over to a hospital. Those working in that hotel will receive the pandemic pay. One question asked of me was whether or not it would apply to cleaners or maintenance people. And my answer was I wasn't really sure. I would think it would be covered under the workplace. And we will provide that answer in the link to the questions that were asked during that webinar. Also on April 26th, which was yesterday, publicly funded schools were ordered to remain closed until May 31st instead of May 4th. Professional activity days and examination days were canceled. Now looking at the City of Toronto, you could only complete construction during certain hours of the day, which are usually business hours, not holidays, not weekends. And so to increase physical distancing, the City of Toronto has said, we are going to eliminate this rule, because then if we have people working throughout the night, you might not have so many people working in the same place at the same time. So another question that was asked of us was, well, what happens with a condominium where we say that we're in line with the City of Toronto? We say that someone cannot work in construction during the same hours that the City of Toronto has said, and now that's been eliminated. What do? You don't actually have to agree to that. That's an option for you. And if there was another question asked about whether or not you can now refuse contractors to go in during certain times because of the noise bylaw exception. And my answer is that you shouldn't refuse anyone, but you see what you could work out. Also, what's very interesting was on Friday, there was a court proceeding filed against the city for conditions in homeless shelters. It was, and it was actually deemed or understood to be an emergency. So what happened here was there were issues stated where it said that beds and cots were still only 2 feet apart. People are in bunk beds and bathrooms aren't being cleaned anymore. And so what the court said on Friday is, okay, this is an emergency, and everyone attended court this morning to schedule a timetable and a hearing. The symbol below is the court system. And so I just wanted to briefly cover that civil criminal jury trials have been postponed until at least September 2020. So what that means for you is if you received a jury notice to attend court in July or August, you don't have to go because it's postponed until at least September. If you are in a legal proceeding or a court case and your decision maker is only a judge, it doesn't necessarily mean that your trial will be postponed. Also, the courts are dealing with virtual matters. We have one later on this week, which is a settlement meeting with a judge by Zoom. There's also urgent bankruptcy matters that will be heard virtually. And you may also continue to file your lawsuits and your defense online. So I'm going to briefly ask, and I'll pull up the poll. What property issues concern you the most? And so there could be contractor, occupancy, protection. If you can use a phrase in a contract that will pause it, delayed real estate purchase, none of the above, or other. And please go ahead and vote. And so here it was delayed real estate purchases. And if I can use a phrase in a contract that will pause it. And so speaking about phrase isn't to pause your contract, it's actually called a force majeure. It means a superior force. There's something that happened that caused me not to fulfill my end of the bargain. Please do not sue me. It's not my fault. Or is it the other way around? And so what I see are the judges are very strict in how they interpret these paragraphs. It has to address exactly what you're relying on it for. And if it doesn't, then you can't rely on it. So in a situation of COVID-19, your phrase in your contract should actually address something having to do with a national emergency pandemic, something along those lines. It's not just good enough to say, I have this paragraph, so therefore it's good law. An example of that is Frederick Transport Limited and Gateway Systems Limited, or versus Gateway Systems Limited. And what happened here was there is a paragraph in the contract that said, if there's a delay crossing the border due to delay with getting a government permit, it's not my fault. Don't sue me for damages due to delay. That happened when the truck was crossing over from Canada to the US. They ended up in court. The judge said the paragraph in the contract speaks to this issue. That person or company is not responsible. In the situation of Fishery Products International Limited versus Midland Transport, there was an issue regarding a protest and a strike. So the contract said, if there are any delays because of a strike, and a strike is usually when employees in the company, it's internal, are saying, I want better pay, better working conditions, something along those lines, and they stop working. So if there's a delay due to this, then we're not responsible. So there was a situation where they were driving and there was a delay because there was a protest, a trucker protest. And so the judge said in this situation, a protest is external. It's not the same as a strike, that's internal. So therefore, you are responsible for losses because you should have included that in your contract. So my question to you is, looking at this phrase, which was provided to us by one of the attendees, the concern here is, I don't want my locks to be changed on me as a commercial tenant because I can't pay rent due to COVID-19. Does this paragraph help me at all in making sure that my locks are not changed? So I'm going to, it's a long paragraph, but the hints are the bolded words, inability to obtain and utilize labor, material, or supplies, speak about an emergency, other cause beyond reasonable control, and you shall be excused. So looking at this phrase very quickly, do you believe that if someone relies on this to say, don't lock me out, landlord, it is actually valid? So please, could you please vote now? So it's tied, half and half. So my thoughts on what the correct answer is, it is yes. But there's certain requirements. The first is, please tell the other side in writing that you're going to rely on this. It's important to keep the business relationship alive, so you should have a conversation before and then follow up with an email and say, further to our conversation, I'm relying on this paragraph. The reason why is we're trial lawyers, and many times when we go to trial, there's not enough written proof, and therefore it's difficult for a judge to make a decision in your favor because the proof is not there. If you don't have this paragraph, or if this paragraph is not thorough enough, you should consider these 4 things. Make sure your paragraph speaks of the reason, like if I can't complete this, my end of the bargain for this reason, what are the consequences, right? I won't be noted, you won't change the locks on me, you won't sue me, and explain why it was out of your control, pandemic, state of emergency, and what are you doing to minimize your losses should be taken into account. So what I mean by that is, judges, if you decide to go to court because someone didn't fulfill their end of the bargain and you had to pay more money, a judge is going to look at what did you do to minimize that damage to you. If your supplier says, I'm not going to supply this to you because of COVID-19, and you don't agree that the paragraph covers that, then did you try to go out and buy another supply from another supplier? And if you did, then your lawsuit is the difference in price that you had to pay for that person not fulfilling their end of the bargain. So some tips. Try to with your contracts, try to renegotiate your contracts to include this paragraph. You should try to renegotiate your contracts, period. Ask for deposits for rent to be applied to outstanding rent. So many commercial tenants have had to submit rent in advance. And so if you're having difficulty paying rent, maybe you want to ask your landlord, could you just apply it for this month? And I will try to give you a new deposit in 90 days or within 6 months. And for commercial landlords, you should try to learn from this by getting the biggest deposit possible. There isn't any law like there is with residential tenants on how much your deposit can be. Try to determine what your damages would be if someone did something you believe was wrong, and ensure that your superior force paragraphs are specific to your needs, but they are very comprehensive. So I will pull up the poll on construction projects. And so contractors were working at the property when Ontario declared a state of emergency. Either contractor or homeowner does not want that attendance at the property due to COVID-19. What are the consequences of not accessing the property? So either A, the homeowner may be able to impose financial penalties. B, the contractor may be able to impose financial penalties. C, it's a pandemic, so anyone can end the contract without any consequence. Both A and B, none of the above, or unsure. Could you please vote? So it looks like the answer is that was provided as both A and B. So I'll ask Jordan to take it from there and let us know what he believes the correct answer is and why.
Thank you, Tanya, and thank you to those of you who are taking the time to watch this re-recording of our webinar from earlier this afternoon. Tanya, if you wouldn't mind going to the next slide, please. So the correct answer is D, which is both A and B, and you'll recall from the previous slide, those answers said the homeowner can impose financial penalties or the contractor can impose financial penalties. The answer is that both may be able to impose financial penalties depending on the circumstances if one or the other unilaterally discontinues the construction project. So the solution here is really to just sit down and have a chat with the contractor or the property owner. If there's a legitimate reason why construction needs to be put on pause, then you may be able to work that out between you, fix a new payment schedule, fix a new construction schedule, and renegotiate the terms of your contract. The other potential answer that was slated into the poll was C, which is either party may terminate the contract. That potential answer alludes to what Tanya was referring to earlier, the force majeure clause. So it may be the case that your construction contract does include a force majeure clause. If that is the case, the principles Tanya spoke to earlier apply. What is the scope of the force majeure clause? Does it actually contemplate something like the COVID-19 pandemic? What forms of relief does it give? So oftentimes the force majeure clause won't, in effect, take the contract to an end or deem the contract to be over. It will simply put the contract on pause, or it may put the contract on pause and impose certain financial penalties. The point is it'll be on a case-by-case basis, depending on how the force majeure clause is worded. So bearing in mind that the contract pretty much stands, there are some considerations in the background that you want to ask yourself in a situation like this. The first is it an essential or a non-essential business? The second is, how does construction laws affect my contract, and what sort of timelines operate under the construction laws? And the third is, what kind of surrounding scenarios or situations or factors do I need to consider? Are they time sensitive? And if they are time sensitive, how do I get heard by the court given the closures? So going to the first point, which is the project essential or non-essential project? It really depends, broadly speaking, on if you're in the commercial or residential sphere. If you're in the commercial sphere, the kind of Cole's notes on it is the project will be deemed to be essential if it relates to critical industry. So if it's healthcare facilities, something related to food production, agriculture, something that's necessary during the COVID-19 pandemic, then the project itself will be deemed to be essential. It's quite a severe limitation, so chances are a good portion of commercial contracts are going to be deemed non-essential. In the residential sphere, it's much more broad. So any project that was commenced prior to April 4th is deemed to be essential. So with that in mind, as a property owner, you have to say to yourself, if my project is deemed to be essential, then what flows from that is I can't unilaterally tell my contractor not to attend the job site. If it's essential, then the contractor is permitted to attend the site. And if you unilaterally discontinue the project, then you may be faced with penalties. The second consideration was, what are the construction laws, and how does that all play out in the midst of the pandemic? So there was a period of time where the limitation period was frozen. Tanya alluded to that earlier, or time periods under the Construction Act were frozen. They're now reinstated as of April 16th. So the key point here is the clock was running prior to the suspension of the limitation period, which was March 15th. It's now reactivated as of April 16th. So as of April 16th, it's not that the timelines under the construction laws are reset or have restarted. They've continued on from where they've left off. So you need to be cognizant of that when you're calculating any periods of time. One example is lien rights. So that is one thing that Walker Law deals with quite a bit. And there are very strict guidelines under the Act governing how long you have to register a lien, what is the registration requirements in terms of documents. A lien is basically a document that tells the property owner, I am a contractor and you owe me money for labor and materials that I have supplied to you, and it's registered on title to the property. So there's a very short window for registering the liens. The party should be cognizant of how the Construction Act interacts with your project. The third consideration was surrounding circumstances. So one example is with permit issues, right? So if a permit is time sensitive and will expire as of a certain date, and it was a long, drawn out, expensive process to acquire that permit, it may be deemed urgent. So you may be able to go to the court and have your permit put on pause, or make it so that it doesn't elapse and expire because of the hardship that will flow from that. So that's just one very generalized example of something that can be deemed to be urgent. Another question that we actually received during our webinar was something that Tanya alluded to earlier. Can a construction project in a condominium be permitted to continue during the pandemic? To elaborate further on what Tanya had said earlier, one example in the case law was a residential condominium owner who decided to forge ahead with construction, and the condo board brought an urgent motion to get an injunction preventing her from continuing construction. They were given they were granted the injunction. The point here is, even though your project may be deemed to be essential by the Ontario government, if a condo board says that for their own reasons they want to cease the project, they generally will have authority to do that, depending on what their binding or their overarching documents say. So that would be your declaration and your bylaws and your rules. In that case, a large portion of the residents were senior citizens, and their safety was thought to be put at risk by this. There was also access through a common lobby, so there was fears of contamination of the common elements and people contracting COVID-19. It may be the case that if you're in a condominium unit, a townhome condominium unit, you have a separate entrance. Risk of contamination of other unit holders is very low, that you may be able to have leverage to work with the condo board to encourage them to allow you to proceed. But again, it's going to be a situation by situation basis. And I'll turn it back to Tanya.
Thank you, Jordan. So there is another poll about new condominium closing. And so a new condominium was purchased and it is ready for occupancy next week. The closing is supposed to occur in a month. How does COVID-19 affect the responsibility to pay occupancy and to close? So the purchaser may terminate the agreement and receive the deposit back, delay the move-in and payment until the pandemic is over, work with the developer to change dates, abide by the original contract, none of the above, or you are unsure. And so 50% of you thought that you could work with the developer to change dates, or you must abide by the original contract. Jordan, do you want to take it from there?
Yep, thank you, Tanya. So both of those answers are correct in a sense, but the most correct answer or course of action for a purchaser would be to try and work with the developer. So the contract is binding, which is why the other answer that was given is partially correct. In the background of things, you have to bear in mind that the contract is a binding commercial contract, and it is the developer's right to enforce the terms. But you're not prevented from trying to renegotiate those terms. So as a purchaser, you can try and set new occupancy dates or negotiate occupancy fees, have those occupancy fees restructured. If you don't ask, you won't know. So in our mind, the most correct answer would be to try and renegotiate. There's no harm in doing it. If you are found to, or if the developer does take the position that they want to bind you to the agreement of purchase and sale and all of the terms that surround that, then you may be put in a tough position and be required to take occupancy of the unit and pay the fees. With that being said, the agreements of purchase and sale generally contemplate situations like this, and the developer will generally have the right in the contract by clauses or paragraphs similar to a force majeure that allow them to unilaterally push out the closing date or the occupancy date, depending on what circumstances are contemplated in the agreement. Tarion has issued additional guidance and requirements for condo developers to release certain forms of notice if they are going to push out an occupancy date or a closing date due to the COVID-19 pandemic. So there are specific forms of notice that need to be given if the basis for shifting a date is the pandemic itself. Some other considerations you want to think about is the other protections that are provided under the Ontario New Homes Warranty Act, which is the act that deals with new developments, new construction, residential construction. Those are more or less still in place. So your warranty rights, your inspection rights are all still intact. There have been some modifications to that. So your submission deadlines or filing deadlines for your warranty claims are suspended, but the expectation is that you'll still file or make efforts to file those things on time where possible. Another example would be your pre-delivery inspection. So prior to taking possession of a unit, you and the developer would typically attend the property, walk through it, and identify collectively any deficiencies that you see. And that would be documented as part of what you're entitled to in your warranties. In order to accommodate the need to physical distance from one another, Ontario has issued guidance saying that these pre-delivery inspections can now take place separately. So the expectation is the homeowner will schedule a date, go in, take their photos and videos, document the deficiencies as they see them. The developer will go in at another date, and then the parties will coordinate digitally, separate and apart, to try and figure out what the pre-delivery inspection notes should be. So those are just some very basic examples. One other question we had earlier today in the webinar was, there are other forms of financial relief for commercial tenants. Is there any sort of relief in the pipeline for new condo purchasers to deal with these occupancy fees and whatnot? As it stands, the government hasn't contemplated any sort of financial relief specifically for the condo sphere. Who knows if that will come to light, but as it stands, we haven't seen any indication that the government will move on that form of relief. And with that, I'll turn it back to Tanya.
Thank you, Jordan. And also on the same note, I do expect that legislation that came out on Friday to perhaps be further amended or clarified to answer the questions that people have posed through this webinar. So I'm not sure if I unmuted myself. I don't think I did. But on another note, that just keep in mind that the legislation is all legislation concerning, I would believe, every aspect of law in COVID-19 is subject to change. We've seen numerous changes since COVID-19 actually has started. So now the next question that I have for you is another poll. And a business has been shut down due to a government order and it cannot pay rent. What are the options for the landlord? So it depends on what the lease says. There's no consequences as there can be no evictions. The landlord may eventually change the locks, unsure, or none of the above. Would you please vote? So the answer we received was no consequences as there can be no evictions. And sorry to say, but that answer is incorrect. No consequences as there can be no evictions actually deals with residential property, not commercial property. And the interesting fact is, when you have a residential property and you want to evict the tenant, you can actually file your materials now. You have to call the board to find out if they'll accept it by fax or email, if they're accepted at all. Your hearing may be scheduled on the phone, and so that decision may be made, and I urge you to do that right away. That question was actually asked us by Jason Bogle. And so you're first in line. But if the enforcement, like to get that tenant to physically leave the property, that could only be done by the sheriff, which is the government. You can't actually go out and hire somebody on your own. That is very different when it comes to a commercial property. with a commercial property, the landlord can walk in after typically 15 days, change the locks, and then you're no longer in the lease. And the landlord can also sue you for the money due under that rent from that point on until the end of the lease, with the expectation that the landlord will try its hardest to find someone else to rent the unit. So there was another question that was asked of us, which is, does the landlord now have an obligation to work with the tenant due to COVID-19, especially if the tenant is operating a business that is not essential? And unfortunately, our answer is no. Unless there's something that speaks to that in the lease, there's no obligation of the landlord to work together with the tenant to ensure that the tenant stays in the premises. There's not even an obligation of the landlord to accept that reduction of rent of 75% and to participate in that program. So it's important to try to renegotiate your lease and see what can be done to stay in the premises. So examples of what I would recommend, knowing what we know now, right, is you might want to renegotiate your lease to include an escalator phrase. And an escalator is simply the same, what it is, like an escalator moves up. And your rent is tied to your profit or your revenue. So your rent that would be due is maybe 10% or 5% of your revenue or profit. It's a little bit intrusive because you would have to provide your financial information to your landlord. But that's, if you had that type of phrase, your rent you would pay now for a non-essential business would probably be zero. You also might want to consider renegotiating a lease, or when you enter into a new lease, that contains a lease contingency phrase. So what essentially that means is, if you have a store in a shopping mall, you may have a phrase in your lease that says, well, if the shop, you are only expected to pay rent if the shopping mall is operational. If the shopping mall is not, then you should not pay rent. That would save you if you had that phrase in your commercial lease. So there's another poll for closing on a building. We signed a new purchase agreement for a new building for our business, and uncertainties from the pandemic may make closing difficult. Are we able to delay the closing without a financial penalty? So one of your answers is yes, there will be financial penalties. Yes, but the purchasers will lose your deposit. No, you have to accept close and accept the property on time. Yes, the seller will have to accept the lower price the property sells for less. None of the above are unsure. So 100% of you agreed that there will be penalties. Yes, you are able to delay the closing, but they will be penalties. And so my response is that answer, I'm sorry to say, it's incorrect. The answer is C. You haven't, unless your agreement of purchase and sale speaks to a situation or financing, you have an obligation to close on the sale of property. The leading case is a case called Runnymede versus De Palma. It's from a long time ago, but it's still what we say good law. And what it says here is if the purchaser refuses to close or cannot close on the sale, the deposit goes to the vendor. I've had situations where the vendor actually sells the property for more money, and gets to keep the deposit anyway. So it has to be seen as a deposit, not part payment. Part payment could be like half the price of the property. So this is important to keep in mind because most agreements of purchase and sales are signed on the standard Ontario Real Estate Association form, and they don't contain these type of paragraphs. So it's important to negotiate that yourself, knowing what you know now. So some recommendations of what you might want to include in these type of agreements, and keep in mind that a copy of this presentation will be sent to you, so it'll be easier for you to kind of tweak these paragraphs if you would like to rely on them, is first for financial inability. Now you know now that the purchaser loses the deposit if the purchaser doesn't close, you may want to have a paragraph in there that says, if I'm unable to close because I'm unable to get the financing that I need, the vendor will get 50% of the deposit. Secondly, you might want to have a financing clause paragraph that says, If I am unable to get a loan to finance the property, then I may cancel this agreement and the deposit will be returned back to me. Another last point on how you can protect yourself when there's an agreement of purchase and sale is you can speak of a civil disruption, international emergency, a pandemic. Then you are allowed to delay the closing for 90 calendar days after, the pandemic is no longer a pandemic, or the state of emergency is no longer a state of emergency. So those are three type of examples that you may want to include in your agreement of purchase and sale in the future. So to conclude, I thank you all for tuning into this webinar, whether it was live or a recording. Feel free to send questions to me if they weren't answered. My contact information is at the bottom of the PowerPoint presentation. Also, please provide your feedback to us. I know you're incredibly busy, but this is how we even came up with this type of presentation and the question answer, because you told us that's what you want. So in order for us to give you what you want in the future, we need to know and for you to communicate that with us. Keep in mind our Zoom presentation that will be held on May the 8th. I'll be moderating that. This is recorded, so you won't be able to ask me questions live, but I'll be happy to take your questions if you send them my way. Thank you very much, and stay healthy and safe. Thanks again.
Thank you.